Welcome to another episode of the Federal Newswire Lunch Hour Podcast with your host, Andrew Langer.
Well, hey, everybody. Welcome to another episode of the Lunch Hour with Federal Newswire. I'm your host, Andrew Langer, and we appreciate everybody who tunes in on both the YouTube channel and on one of the many fine podcast platforms that carries the Lunch Hour's audio file. We really appreciate that. And if you are watching and or listening, please subscribe, leave a like, leave a comment, and most importantly, let your friends and family members and everybody you know that you're a fan of the Lunch Hour with the Federal Newswire. I don't want to keep my guest waiting any longer. I'm going to peel back the curtain. With some technical difficulties this morning, he's been gracious enough to hold over a little bit longer today. His name is Glenn Roper. He is a senior attorney with the Pacific Legal Foundation. And if you've spent any time watching or listening to the show, you know how much of a fan of PLF I am. Glenn, I'll read your bio in a second. I was just up in New York a couple of weeks ago, having a meeting with someone at one of the big law white shoe law firms, and talking about my background and I don't have a JD. And he said, "Well, would you have come to a place like where we are to practice?" I said, "You know something? No, I probably would have gone to practice at some place like the Pacific Legal Foundation, because they do the kind of work that I think needs to be done." But Glenn, let me read your bio a little bit. Glenn joined PLF in 2019, working in the Equality and Opportunity Practice Group. He's based in Colorado. He litigates across the country on behalf of individuals and organizations to advance the principles of individual freedom, opportunity, and the rule of law. With experience in both federal and state government, Glenn has seen the dangers posed to liberty when agencies, bureaucrats, and politicians ignore individual rights in favor of expediency or advancing a political agenda. His interest in combating these dangers centers on two areas: protecting the principle that everyone should be treated equally before the law, regardless of race, color, or creed, and expanding opportunities for entrepreneurs and small businesses to make a living without being burdened by unreasonable regulation. Y'all will see a theme here in terms of both the work that we talk about here on the Lunch Hour and the work that I do. We're going to talk about his time growing up in California's Central Valley. He spent most of his career in the Mountain West, worked for the Attorney General in Colorado, worked as a Deputy Associate Counsel in the White House Counsel's Office for President George W. Bush, clerked for Judge David Ebel of the 10th Circuit Court of Appeals, graduated first in his class from Brigham Young University Law School. We're going to get to your recreational ideas. I mean, Glenn, I guess that makes sense growing up in the Central Valley. Where'd you grow up in the Central Valley, if you don't mind my asking?
Yeah, I grew up in a smallish city called Porterville, which is between Fresno and Bakersfield.
Nice. Nice. You mean the metropolis is between which the California high-speed rail goes?
Exactly.
There you go.
Right in that area. Lots of orange trees, lots of cows, and great people there.
That's terrific. And then Brigham Young is a unique experience. We've got family friends who've gone there, and that's amazing. Where'd you go? I'm sorry, where'd you go undergrad?
I was also at BYU.
Yep. Got it. And then you stayed in the Mountain West and practiced law there. For folks who don't understand what Pacific Legal Foundation does, tell us a little bit about the cases you take on. I mean, it's bound up in your bio to an extent, but it goes much further than even because you practice on two discrete areas of law. Talk about generally what PLF does.
Yeah, PLF is a public interest law firm, so it's different from Smith and Jones or one of these big law firms that you go to. In that we provide legal services for our clients, but we do it free of charge. And that's because we only take a certain amount of cases or a certain type of cases. We don't just take everything that has a paying client. We take cases that are able to have an impact, that we think will be able to set valuable precedent and help us move the rule of law forward.
And you have, as a firm or an organization, you have an extraordinary track record. How many Supreme Court wins? You guys just racked up another one this term, didn't you?
We did, and that was number 18.
Wow.
So we have 18 Supreme Court victories. Really, an unmatched record by any organization of our kind, and really most law firms, even the big law firms that practice a lot in the Supreme Court, aren't going to have that kind of record usually.
Well, I mean, it's a credit to the scholarship of the work that you guys do, and of course the issues you take on. They're vitally important issues. We're gonna get to some of those. And actually, let me sort of dovetail into a general principle. Are you guys representing the plaintiffs in the Loper case or not? And I know that's not your area necessarily, but they're not PLF clients, are they?
They're not PLF clients. We didn't file an amicus brief in that case because it, as you know, addresses the important question of Chevron, what's called Chevron deference.
Time out for a second, because that's why I bring it up, because you wrote a great piece in The Hill a couple of years ago about the issues of bureaucracy and where bureaucracies ought to lean. So that's why I wanted to ask you about this, an issue near and dear to my heart. Go ahead, sir. I'm sorry.
Yeah, no, those cases are going to test the viability of what is called Chevron deference, which, as you know, and I'm sure many of your listeners know, is a doctrine not found in the Constitution or in the law anywhere, kind of made up by the Supreme Court, where they say when an agency, a federal agency, interprets a law that they administer, then the courts have to defer to that interpretation as long as it's reasonable. So when Congress enacts a statute that says, the agency must do X, and the agency says, well, we think that means we have to do, this certain thing, then the courts, instead of looking at the law and deciding what Congress meant, they will just defer to the agency. And the Supreme Court has heard argument there, and they'll be deciding whether that doctrine is going to continue.
So we've had a lot of conversations on the show with a number of scholars about this, and most pointedly had a conversation with Veronique DeRougy at the Mercatus Center at George Mason University. And she levied, I think, a very interesting warning, which is in the same way that conservatives were not prepared for the post-Dobbs world and what that landscape was going to look like. She warns that we are not prepared for a post-Chevron world. So I want to ask you this. It's, again, these are not the cases we're going to talk about, but what do you think a post-Chevron world looks like? How are we prepared for it? How are you as a legal scholar and an active, public interest litigator, how are you preparing for for a potential post-Chevron world, I should say?
Well, it's going to depend a little bit on what the court does.
Right.
Does it abandon Chevron wholesale? Does it pare it back a little bit? But I think you hit on an important point, and that is we've got to be ready to bring appropriate cases and to give the court some direction as to what we think these laws mean. Just the fact that the court isn't deferring to the agencies anymore doesn't mean that the courts are going to be It doesn't mean that the courts are going to be accurately or appropriately interpreting the law, and we've got to be prepared to offer them interpretations and ways of interpreting the text that Congress has enacted that will actually, follow the rule of law as opposed to just what the agencies do. I think also we shouldn't get too overly excited about the potential repeal of Chevron or overturning of Chevron, because you're still going to have the same individuals serving in these federal agencies. And I think that highlights some of the importance of what we do at PLF, is that we've got to be prepared to bring cases against those agencies to push back on overreach that they do, because there are a lot of ways aside from just, they're going to likely, these agencies are going to keep implementing the same kinds of policies, and they'll still need to be challenged. It'll just mean that with the court, it'll take away, if the court were to overturn Chevron, that would take away one tool that the agencies have in pushing back against our lawsuits. But they still have lots of other tools. The government has a lot of power and a lot of ways in which they get a thumb on the scale in the courts.
And this is why PLF exists, is to sort of push back on this. And the agencies will still have the power to interpret their own regulations, under the Auer deference doctrine, AUER. That's for folks out there. I know Glenn, what the Auer what our deference is. But let's sort of get into some of the work that you're doing, because it is fascinating. They're not twin precepts necessarily, but the idea of equal representation equal representation, but also, equal vision, equal treatment under the law, regardless of whatever identity you have for yourself or claim for yourself or push for yourself. So let's talk about this issue of the work you guys are doing about public boards and racial makeups on public boards. This is interesting stuff. Tell us about it.
Yeah, well, I think your listeners are going to be generally aware that states have a lot of regulatory boards. Probably most familiar would be like the state medical board. Right. It's going to license doctors in the state. You'll have the same thing with dentists, and actually dozens of other professions, everything from accountants to podiatrists to cosmetologists. States have lots and lots of these regulatory boards. And we did a survey, some of our research scholars here did a survey and looked at the statutes creating these boards across the country, and found that in about half the states, these laws, for at least some boards, they will have racial or gender requirements, meaning, for example, that for the governor to, say the governor appoints, and I'll give you some specific examples in a minute, but say the governor appoints 10 people to the board, the law might say, well, 3 of those people have to be racial minorities. And so we identified this as in this research project, and we're now bringing challenges to various of these laws as violations of the Equal Protection Clause.
Yeah. And it gets to this issue of identity politics and racial or gender or some other kind of identifier, so-called diversity, which is not what you want. I mean, if you want, the whole concept of diversity rests on the idea of people bringing different values and experiences to the table, but this presents it as a monolithic thing, as though every member of race X has the same perspective and experience. That's what we're getting at. But of course, and then bound up, of course, is the fact that you do have this idea of we are all supposed to be treated equally under the law. But please go ahead.
Yeah, and not only equally under the law, but the government really should be treating people as individuals.
Yes.
And for some of these boards, having some diverse thought, diverse perspectives is going to be important. As we talked about, I come from a very rural area of California, and people in the Central Valley, they've got a different view of things than people who are in the Bay Area or in LA or in Sacramento. And those voices should be heard. But what these laws do, they will actually constrain the ability of, it's most often the governor who's making these appointments, but they'll constrain the ability of the governor to identify the diverse and most qualified individuals and say, no, you've got to not just look at that, you've got to look at skin color, you've got to look at gender in making these appointments, and you've got to appoint them within these certain parameters.
And so you guys, I know, have done challenges in what 24 states or so. You won big in Iowa. You've got something going on in Alabama. Talk about that.
Yeah, we did. It's not quite 24. We've got about maybe 6 of these challenges right now in various states. And we did have a big victory earlier this year.
And I'm sorry, it's about 2 dozen states that engage in this practice, but you guys have. Yeah. That's what I meant. Got it. Sorry.
Yeah, exactly. We found about half the states, 24 states.
Wow.
That have this practice. In Iowa earlier this year, we had a big victory. Iowa had what's called the Judicial Nominating Commission, which is a state board that picks who's going to be the next judges in the state, the Court of Appeals judges in the state of Iowa. And they had a law saying there has to be the same number of men and women on the board. It has to be divided exactly equally.
Okay.
And what that meant is our client, who was a woman who was interested in being on the board, because she happened to live in a district that was a quote unquote male district, she was not able to be considered for this board because she wasn't of the right gender.
It's crazy, but it's also crazy when you take into account, not that I necessarily, even if you don't want to talk about Title IX and the definition of what's a man or what's a woman. But because it's 2024 now, I mean, a lot of this stuff goes out the window, right? I mean, all of a sudden you've got, let's say, not that I'm not going to get on a political grandstanding stool here, but let's say that you are a woman and you all of a sudden lose out to someone who had been born a man but is now identifying as a woman. I mean, that all gets into this mix, doesn't it?
Yeah, fortunately, we didn't have to get into that issue in our case. But it is 2024. It's a different world than it was 100 years ago when or decades ago when this gender quota was put in place. You've got a female governor of Iowa. You've got a female senator from Iowa. There really isn't a need, if there ever was, to say we've got to promote women on public boards by having this equal gender split. And ironically, even if the purpose originally was to enhance the number of women on the board, the fact right now is our client, who is a woman, is being kept off of the board, or was being kept off of the board before this court ruling because of the gender quota.
It really then gets down to the number of these boards that are out there and the role that they play, and why we want public participation on these boards. And it gets down to exactly what you're saying, that it comes down to the individual. You want someone with the core competency who deals with these things and not this other, right? We got away at some point in time, and I've done some seminars on this with the folks at Constituting America. It gets down to the issue of, are we a society in which are we a meritocratic, in which we are rooted in meritocracy, or are we rooted in some other things? I want to hear your thoughts on this. I mean, where did we sort of veer off this issue of you rise and fall by your own merits, and as opposed from the gender you're born or the skin color you have, or you're from a particular ethnic group? Your thoughts here?
Yeah, we're seeing that not just in these public boards, school admissions. That's an area where the issue of merit has really come up, and this contrast between identity and merit. We fought a number of these admissions cases where Asian students were being discriminated against because they were being too successful in getting admission into these schools. The Supreme Court addressed some of these cases in the Harvard decision last year. We brought a case in the high school area. I'm not sure if you're familiar with Thomas Jefferson High School.
Oh, sure. Absolutely. Hold on. Let me digress for a second there, Glenn. So my graduating class, or my freshman class at William and Mary, Virginia State School, Thomas Jefferson High School Science and Technology, folks, is a magnet school up in Fairfax County, Virginia. The graduating class, their very first graduating class, a class of 89, 360 students in that class, 60 of which were in my freshman class at William and Mary. And I knew most of them. So statistically speaking, right, in an entering freshman class of 1,200 people at William and Mary, there was at least one pair I know of that were randomly assigned rooms together through the process here. But yeah, I knew a lot of the nerds, very familiar. But I'm sorry, go ahead and talk about TJ.
Yeah, well, you know that TJ is a very prestigious STEM school there in Northern Virginia. It's been rated as the best public high school in the country numerous times in the U.S. News and World Report. Unfortunately, the school board there decided that there were too many Asians getting in, and so they decided to change the admissions policy to try to keep the Asians out. We brought a lawsuit. We won in the district court. The Fourth Circuit reversed us, and unfortunately, the Supreme Court declined to hear our case. I think that was a big loss, devastating for our clients. But I want to just highlight that this school that had been top, ranked number one consistently. The rankings came out this last year after they changed their criteria to get away from that focus on merit, because I should have mentioned this. All the Asians who were getting in were doing so under a system that just looked at things like test scores, grades, admission essays. Well, they went away from that to include this focus on race. Numbers came out just a few weeks ago. TJ has now dropped to number 14 in the rankings. And certainly the schools do not have to focus on merit, just like universities. I think Justice Thomas made this point. You don't have to try to be an elite university if you want to just be open to everyone. But what you can't do is try to say we're going to be an elite university taking the best of the best, just focused on merit, and then also say we're going to look instead at these factors such as race or these other immutable characteristics and give people a bump from that. And so I think the drop in TJ's rankings, I think, is reflective of this moving away from a focus on merit.
It's funny. In addition to the policy work that I do, I should say, in addition to the media work that I do a lot of policy work on regulatory policy. But I've spent a lot of years in radio. Reminds me of a radio station I worked for where I used to have a little bit of gallows humor. Like you would think the radio station wants the best ratings that they can get, to be top notch. And as I used to comment, watching the way decisions were being weighed, no, they want the best ratings at the price point at which they're willing to pay for talent. So, it is, it definitely, this tends to infect. Let's shift our gears to some of the other great work that you're doing at the Institute for Justice. By the way, the website is ij.org. I know it's not your,
sorry,
what?
We're IJ is a great organization. We're Pacific Legal Foundation.
Oh my God. Did I do that? Okay. I gotta, oh, wow. Well, both organizations are great organizations. Thank you very much for that. I'm going to bang my head against
No worries. IJ is great, and they do a lot.
Is a fantastic organization, and again, one of the best. What threw me off? It was because we're talking about TJ in Fairfax County, and one would have thought that this would have been an IJ case. Anyway, setting all of that aside, my apologies, Glenn.
No.
Good Lord. All right. Well, you guys are doing great work on things like asset forfeiture and other kinds of set-asides. Let's go to the set-asides issue first. The case you guys have going on, Herholzer versus Guzman, which has to do with contracting issues. Tell us about that case and what's happening.
Well, as you know, Andrew, small businesses really are the backbone of the American economy in a lot of ways. And the Small Business Administration is the federal agency responsible for regulating and promoting small businesses. They set up what's called the Business Development Program, where particularly needy businesses, small businesses, they'll provide some additional help. They'll set aside contracts for those businesses. They'll give them some business development training and give them other kind of perks to help promote those businesses. To get access to that program, you have to be what they call a socially and economically disadvantaged business. Right. Unfortunately, and the basis of our challenge is that they've decided that to be socially disadvantaged, they're going to presume that you're socially disadvantaged if you fall into certain racial categories. Right. You're shaking your head because you've seen this before.
Right. This is the soft bigotry of low expectations. Go ahead.
Yeah. Exactly. So if you're a Black-owned business or a Hispanic-owned business, they will assume that you are disadvantaged, and so you can get into this program. Whereas if you are a white-owned business, you don't get that presumption. You've got to prove to them that you're socially disadvantaged. Our client, Marty Herholzer, is a service-disabled veteran. He was a deep-sea Navy diver for 2 decades.
Wow.
Some of the, he could tell you some cool stories about some of the diving that he did. But after he came back and retired from the Navy, he set up a business providing services, some that he had seen missing for military contractors and for the VA. He wanted to take advantage of this business development program that the SBA had, but because he's white, doesn't fall into the preferred racial categories. He didn't get he wasn't able to take advantage of the presumption, and they excluded him from the program. They said, well, being a service disabled veteran, that's not enough of a disadvantage for us to let you in the program.
Wow.
So I think you could have varied opinions on that particular piece, but the basis of our challenge is to say, look, if he came to you and said, instead of a service disabled veteran, I am Black or Hispanic or Asian, or one of these 4 or 5 categories that they have, they would have just let him into the program. He wouldn't have had to prove anything about his social disadvantage. And so we brought a challenge under equal protection, saying the government can't do that. They can't just discriminate on and give people a leg up if they fall into certain racial categories, but not others. Where the district court unfortunately dismissed our challenge, so we're now on appeal to the Fourth Circuit. We filed our opening brief there and hoping to have argument sometime in the next 6 months.
It really underscores the lunacy of this policy. And again, the problem, of course, when the federal government gets so big and vast that it picks winners and losers and it games the system. But you guys are not all about. So we just talked about the Thomas Jefferson issue. By the way, the website is pacificlegal.org. pacificlegal.org. I'm going to be pinging on that for a while there, Glenn. We just talked about something going on in Fairfax County, Virginia. You guys do stuff at the state and local level. Talk about this Joshua Saby versus Butterfield case, because this really struck me. It's important. There's a real personal. I mean, they're all personal stories. That's part of the great thing about selecting the right plaintiffs here. But talk about the Joshua Saby case.
Yeah, well, this is sort of now for something completely different.
Yes.
We've been talking about some race issues. We talked about Chevron, but I think this really kind of highlights the breadth of our work in pushing back against government overreach of all kinds. And I think the story here is so poignant and highlights some of the concerns about the government not following the rules. So Josh Saby and his wife Sarah, they lived in Massachusetts. They had a 3-year-old child and they had a 3-month-old child. So 2 boys. The baby developed a fever one night, and so they were pretty concerned about that, as new parents are.
Right.
Took the baby into the hospital with 103-degree fever. Wow. They ran some tests, did an X-ray. Well, in this X-ray, they found that there was that the infant, the 3-month-old, had a healed broken rib. And that showed up on the X-ray, and so they asked the parents, "Hey, the X-ray is showing this broken rib. Do you know what that's all about?" They didn't. It was news to them. They'd heard of it, and that prompted an investigation, a child abuse investigation.
Jesus.
That the hospital does. They interviewed the parents. That process was pretty traumatic. They brought the child in to try to get this fever taken care of, and it took a right turn to this child abuse investigation. And I don't want, I think it's appropriate for the state when there's evidence or something like this for them to look into it.
Yeah, time out for a second. One of the things I talk about when we talk about law and basic concepts in law, right, is the law is supposed to work to protect those who are harmed and least able to defend themselves. And so that's why we have very strong laws protecting children from abuse, et cetera, et cetera. Anyway, go ahead. So we have this situation. Yeah. I'm in agreement here about this, but we know there's a turn here.
It's coming. Complete. For sure. Yeah. So they did this investigation. They called the pediatrician. They interviewed the families. They even interviewed the 3-year-old son. Had them did all sorts of scans. Found nothing else. No other evidence. There's no substance abuse in the home. No domestic violence. Police had never been called there. Nothing. So eventually they discharged him from the hospital. They said, okay, we want to monitor you for the next couple of months. So they developed a plan together.
Wow.
We'll check in every week, every couple of weeks. Okay, that was a little annoying for the parents, but I think they understood.
But time out for a second,
go ahead,
Glenn. It underscores the fact that in these kinds of circumstances, because there's a lot of subjectivity that's involved here, you get somebody that's got a bee in their bonnet, or, the old adage, if you're a hammer, everything looks like a nail. You've got someone who zeroes in on the Sabys, and all of a sudden it becomes a nightmare for them. I'm sorry, go ahead.
Yeah. Well, and the nightmare, I haven't even gotten to the nightmare.
Okay.
Right now, we're talking about some inconvenience. We're talking about, being this immediate suspicion that is cast on the parents.
Right.
That's uncomfortable. They are a little unhappy about it.
Right.
Whatever. They go home. They're sent home. Things are fine. They think. 3 days later, 1 a.m., there's a knock at the door.
1 a.m.
1 a.m.
Wow.
On a Friday night. And who shows up at the door? 3 armed policemen,
Of course.
and 2 social workers.
Right.
And they say, we're here to take your children.
Oh, my God.
No warrant, no paperwork of any kind. There'd been no advance notice. They'd had several days in which they could have come and seen the children. In fact, they had visits to the home,
Right,
to check in on the circumstances there. But at 1 a.m., the police come up and say, we're taking your children away.
Right.
And this is the nightmare scenario.
At a time when, here's the thing. I'm not, not military, not retired military, but military dependent, known lots of folks in the service. The age old thing is, if you're leading a raid on somebody, you strike them in the hours between midnight and 5 a.m. because that's the time when someone is going to be least alert and least able to defend themselves. They picked an opportune time there. Go ahead.
Yeah, and it's just Josh and Sarah were with it enough, even in the middle of the night, to record some of this, and the recordings are just heartrending. They push back, they try to fight a little bit. They get a lawyer on the phone, but ultimately they're told, look, give us your children or we're going to break the door down and come take them away.
Oh my God.
So they wake up their children. The 3-year-old has no idea what's going on. He's screaming.
This is a
you can just hear this
trauma in some kid's mind, by the way. I mean, the 3-month-old will have no memory of this, but the 3-year-old, this is going to stick with the 3-year-old forever.
Yeah. And remember, the 3-year-old, they'd found nothing, no evidence of anything. With the 3-month-old, they'd found this healed evidence of a rib injury. Yeah. And the parents, not knowing what else to do, they, at the threat of force, they relinquish their children, and they're driven away into the night. They don't know where they're going. They don't know how they're going to get them back. The courts are closed until Monday, so there's no recourse to go to a judge.
That's an excellent. It's essentially Saturday morning. Sorry, go ahead.
Yeah,
I mean,
exactly.
I have 2 kids. I don't know how many kids you have, but I this is just my anxiety is going up listening to this. Go ahead. So
I have 4 kids, and it's just the thought of this is terrible, and it was terribly traumatic. They didn't know what was happening. They just knew their kids had been taken. Well, fortunately, they were able to get both dads. Josh's dad and Sarah's dad are both lawyers. They were able to get the family all involved, doing research, figuring it out. They were eventually able to get the kids placed with the grandparents, with Josh's parents. So at least they were with family while this got sorted out. And then they went through, a multi-week investigation process, court hearing, and we're finally able to get the children.
Because I want to come to the process, but how long did it take them to get from the foster parenting situation back to Josh's parents? How long did that take?
They were able to do that within a day.
Okay, good.
Which is unusual. And I'll come back to this point in a minute, but Josh and Sarah were lucky in that they had the resources and education and know-how to get that much.
Thank goodness. Absolutely. Sorry, go ahead. So the process. Then the labyrinthine process begins. Go ahead.
Yes. Once the state takes custody of your children, you then have the burden to try to prove that you should be able to get them back. And that requires more investigation, hiring lawyers, going before the court and trying to prove that, this suspicion of abuse is unfounded. And eventually it took so they were able to get temporary custody with supervision from child services, and it was about a 4-month process to finally get full custody of their children returned.
Wow. But, and during that supervised process, I mean, how much access were they required to, I mean, not just required, they were required to give total access. How many times was Child Protective Services in their house, doing spot visits and things like that?
Yeah, multiple times a week, coming in, doing interviews, and looking with a skeptical eye at every little thing in the house, trying to find more evidence of abuse. And so, these government workers were basically supervising them for weeks on end.
Wow.
Go ahead, Andrew.
Keep going, please.
No, I was just going to get to our, when PLF got involved, we're now representing Josh and Sarah, and we've sued the state officials who were involved in this. And the reason that this is, obviously the whole thing is a terrible, traumatic situation.
Yeah.
And there are lots of these types of cases, unfortunately, that are going on that we aren't able to get involved with. The PLF connection, we've got a strong property rights practice.
Oh yeah.
And really here, it's the connection of the government abuse plus the property rights violation.
Yeah.
Your home is your castle. For the government to come and breach your home, as happened here, they've got to have a warrant, right? That's in the Fourth Amendment to the Constitution. And there was nothing like that here. No paperwork, no warrant, nothing justifying what they did here. So we've brought this lawsuit on behalf of the Sabies, and really, it's they've done a lot of interviews. They've been very willing to be open with the press about this, and really talking to them. It's inspiring to me, because as terrible as their situation is, what the Sabies say is, we're concerned about the people who don't have the resources that we did, who don't have the fathers who are attorneys, who understand somewhat how the legal system works, who are able to navigate that. Most of the people who lose their children in this manner are poor people,
right?
Who aren't able to necessarily navigate things the way that the Sabies were able to, even as traumatic and terrible as their situation was. So they're hoping to make a change in policies so that this kind of thing doesn't happen to others in the future.
Which state is this in, and is this a suit in federal court or state court?
This happened in Massachusetts, and we've sued in Massachusetts federal court.
Got it. That makes sense. Under what a civil rights violation, section 42 U.S.C. 1983. Have you gone through discovery? I mean, and not that necessarily you want to lay this out, but have you been able to ascertain the moment where the state decided to take away these kids? What sort of triggered it?
Yeah, we're in the middle of discovery right now. Yeah. We survived a motion to dismiss, which is great and unusual in these cases, because the issue of qualified immunity, I don't want to go down that rabbit hole quite yet, but we survived a motion to dismiss on qualified immunity. We're in discovery right now, and that's part of what we're looking into, is that very question. Who made this actual decision, and what was the basis for removing the children?
Now, listen, I mean, Glenn, you go off to law school, and you have certain ideas as to what kind of law you want to practice. But this is the kind of law I get a sense. I mean, we all listen. Everybody, not everybody. If many students, especially if you graduate at the top of your law school class, you want to have that Supreme Court argument at some point, some central constitutional issues, and not that there's not a central constitutional issue here, there is. But to argue a case and to be representing plaintiffs who have been hurt in this way, that's got to underscore why you got into law in the first place, doesn't it?
Yeah, and I tell my wife, so I've worked in private practice, yeah. I've been in government, I've done a lot of different things, and I tell my wife, this is the happiest I've ever been practicing law, yeah. because I personally believe in all the cases that I'm working on.
Yeah.
And that's a unique thing in litigation.
Never forget working for, and I spent high school and college working for this aforementioned big law firm up in New York. And I remember a woman coming on board, Ivy graduate, wanting to know about, well, what if I have to work as a legal assistant on a case in which I don't like our clients, or I don't believe in our clients' arguments. And I'm like, well, tough. That's the way it is. That's why you've been hired. If you don't want to do that, go go somewhere else. Listen, I know your time is limited, and you were gracious enough to wait for me. We had our technical glitch, and gracious enough to stay on when I mentioned the other great organization. This one happens to be pacificlegal.org. As I like to say, and my listeners and viewers have heard this before, at one point I was thinking about doing a podcast focused exclusively on talking to people who are involved in politics and policy about stuff that has nothing to do with politics and policy. Their outside interests, and call it an outside interest podcast. You're living in Denver and spent a lot of time out in Colorado over the years. Beautiful state. And you got 4 kids. Obviously, that takes up a lot of your time. But when you're not engaging in your work with Pacific Legal, how are you spending your free time? What are some of your outside interests?
Well, you mentioned Colorado. It's a great state for doing things outdoors, and we're kind of a hiking family.
Nice.
We love going on hikes in the mountains here. I think with the tennis season coming up here, I should say I played tennis in high school. Didn't really play for the next 20 years, and then my kids got into it.
Nice.
So I've really enjoyed playing tennis recently, and I'm a volunteer coach at the high school. Excellent. For the high school tennis team that my sons are on. That
is terrific. Yeah, we were out in Colorado over the summer and did some hiking and did some horseback riding and just had the best time. My wife has family in and around the Denver area, so we love it out there. How do folks find out more about the good work that you guys are doing at the Pacific Legal Foundation?
Yeah, I think our website is the best source, pacificlegal.org. They can read about the Saby case. They can read about some of our public board cases and the other great cases we're doing. You know, we've got over 100 active cases in litigation right now. Property rights, separation of powers, equality, and would love to have people get engaged and learn about the work that we're doing.
You just had the win this session of the Supreme Court. Do you have any other cases that are up for decision this term?
We have about a dozen petitions to the Supreme Court that they're going to be considering. Hopefully they'll grant at least one of those. A couple of those would be wonderful. That, you know, with the kind of work that we're doing, the Supreme Court, that's like the Super Bowl.
Sure.
Of law. And if we can get cases to the Supreme Court, we can set important precedent, not just for an individual area, but for the whole country. And so that's an important focus for us, is trying to get the Supreme Court to hear our cases.
That's why the work that you guys are doing is so vital, because it has such a lasting impact everywhere. Thank you so very much for joining us today, Glenn.
Thank you, Andrew. It's been my pleasure.
And this has been yet another episode of The Lunch Hour with Federal Newswire. If you like what you're watching here or listening to, you can always watch us on our YouTube channel. You can check us out wherever fine podcasts are found and take us with you in that regard. As I said, please smash down on that like button. Subscribe to either the show on YouTube or the podcast itself. By the way, you can follow me on Twitter. I don't say that nearly enough, at Andrew_Langer. I am Andrew Langer. Enjoy the rest of your lunch.
This has been the Federal Newswire Lunch Hour Podcast, hosted by Andrew Langer. Check out the Federal Newswire's family of websites, as well as their social media stream.